I've had people ask me questions about doing certain procedures and so forth, and then I ask them, well, is that a good show? Does that convince the rest of the world that you're right? Well, it turns out it doesn't a lot of times. Just because you're legally right doesn't mean you're right in the public perception. And who is this public I'm talking about? Well, it's the court clerk, it's the sheriff, it's the marshal, it's the cops, it's the mayor of the city if the case is important enough for him to notice it, and so on. It's all these people who hold the guns. Okay, you want those people to be convinced you're right. Now, they may know they're doing wrong and taking your rights away on purpose, but the first step is to have them know you're right. Now, when they know you're right and they're wrong, that takes a little bit of steam out of their efforts. Okay? There's something about us humans that in general we tend to limit ourselves. Just like I told you the story earlier about the Buddhist monk that was head of all the other monks. Nobody would kill him because they liked him. Okay? He knew how to run his court, so to speak. He knew how to keep things looking good so that as he did his damage, people held back. They didn't take retribution on him, even though he was a major problem internationally for the government. So that's the first consideration. A court is a stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. Now, sometimes you do find somebody not guilty, but basically you're the plaintiff, the sovereign plaintiff. You know what the person did to you. He knows what you did to you. I mean, between you know what the truth is. So why have the court? Well, it's because you're actually putting on a show for the rest of the world. So put on a good show, okay? Don't take shortcuts. It'll pay. So that's what a court really is, in practical terms. Now, there's all kinds of courts, okay? You know about admiralty courts, maritime courts, court of the exchequer, court of claims, all kinds of courts. But in America, there is only one court, and that's a court of record. All the other courts are what we call nisi prius courts. They are courts that exist because you failed to object. Okay?
And you called it what kind of court?
A nisi prius court. That translates from Latin into without prior objection. A nisi prius court is a court that exists because of no prior objection. Okay? So, and you'll see it's right here. You see it, I have it on the menu, nisi prius court. And one time, I got a letter from somebody objecting. And so I put his objection up on the website, and then I put my answer to it, describing a nisi prius court. It might be worth studying. But the important thing to understand about a nisi prius court is it's a court that exists without objection. So all those courts I mentioned are nisi prius courts. Another way, you could call them contract courts, but they're contracted because of your failure to object. See, you don't have to have an overt act to have a contract. I mean, an overt agreement. By the actions of the parties, you know there's a contract going on. You know, if I give you some money and then I walk off and take your car, we never had an agreement to do that, but you accepted the money and I accepted the car. You gave me the keys. Even if we never spoke a word, you know that there's some meeting of the minds there. Some agreement, right? After all, you took the money and I took the car. So a contract can exist on nothing more than the action of the parties. You don't have to have it in writing. You don't have to have the words spoken or anything else. Just what you did that shows there's a contract, an agreement, okay, or stamped a seal on it. And so the clerk stamped the seal on it. It was a rubber stamp, and it had 4 letters, SEAL. Seal. That was their seal. That's the United States District Court. Okay? So that's all it takes for a seal. And so a seal's not exactly a big deal as far as its form, what its form is. However, a seal is an important item. A contract between two parties is always a quid pro quo situation. In other words, you get something for something. You give up something, but you get something in return. That's what all contracts are. Those are called bilateral contracts because they work both directions. A unilateral contract is not enforceable. Okay? If somebody says to you, "I'm going to give you $1,000 on Sunday," you don't have to do anything about it. I'm just going to give it to you. And you make plans on that $1,000, and when Sunday comes, he says, "I changed my mind." You have no case. Okay? Because there was nothing required of you. You didn't have to give up anything to get it. So a unilateral contract is simply not enforceable in any court. Okay? Now, having said that, there's one exception to that rule. And that's if the promise is sealed. If the person says, "I'll give you $1,000 next Sunday," puts it in writing and seals it, the seal is the consideration, and when that seal goes on it, it's real, and that is enforceable. So now they're trying to minimize the importance of the seal, and you'll see that a writing that is signed is considered as good as a writing that's sealed. Words to that effect. I don't remember the exact words that are in the statutes. But the thing that I notice is that all of government, all the courts, they all have seals. So I don't believe what I read. And it's the common law. They're not going to be able to change the common law. The seal is there to stay. Okay? Now, going beyond that, if you look in Black's Law Dictionary, you look up what a court of record is, you'll see in Black's Law Dictionary, the 5th edition, that a court of record has the power to fine or imprison for contempt, and that it keeps a record of the proceedings. Okay? So that's what Black's 5th edition says. It leaves out the other 2 requirements. If you look in Black's Law Dictionary, 4th edition and earlier, you'll find all 4 requirements there.
Interesting.
Yeah. The 4th requirement is that it's proceeding according to the common law. That means no statutes, no codes. Okay? A court of record, the highest court of the land, is a court of record. Okay? No statutes, no codes. So, you're proceeding according to the common law. Anybody ever hear of statute of limitations?
Mm-hmm.
Doesn't apply in a court of record.
Mm-hmm.
Why?
Statutes don't apply.
There's no statutes in the common law. If a court of record's proceeding according to the common law, then statutes don't mean anything.
So they make the bed, they better sleep on it.
Yep. Yes, sir.
Is there such a thing as an Article 3 court?
Oh, yeah.
Well, yeah, but that's under the Constitution. We're outside the Constitution in the common law. We're in an Article 0 court. Okay? My own sovereign court.
So, I guess the first thing is you have to establish that you are proceeding under common law as opposed to statutory law.
Correct. Correct. And I'll show you how to do that. It's real easy. In fact, it's fun. When you see how we do this, you're going to love it. But we'll get to that. But anyway, ultimately, you challenge them. Because by what can we say that one human being has anything over another human being? Well, the response, the inquisitional response would be, well, God sent me to tell you. Now, how can you argue against God? Okay? I mean, that's the ultimate argument, at least back then. Well, if you look at verse 22, it turns out that we're equal to God. That means if we're truly equal, now we're not equal in terms of creating life or creating universes and, a lot of areas, but we are equal when it comes to knowing good and evil. That's the point. And so you just simply say back to the person, well, thank you very much for bringing the message from God. I will take it under advisement. Okay? And you consider it. And if I get a message from God, I'm going to respectfully consider it. But I still have free will, independence, and equality to make a decision as to whether it's truly good or evil, whatever the issue is. And I don't know, might decide the pink shoes are okay if I were the accused, you see. So that's the beauty of that. Now, this is backed up by 1 Timothy, where the full name is Paul's First Epistle to Timothy. And Paul wrote a letter to Timothy explaining a few things. And one of the things that he explained was that he says right in there, the law is for the lawless. Okay? It's not for the virtuous. There's three criteria that he names in there. You have to be faith unfeigned. You have to be, basically you have to have a good intent. And the law is not written for the person with good intent. The law is written for the person who is the lawbreaker. Now what we're talking about here is, you see, when Eve ate the fruit of the garden along with Adam, that was, according to that story, that is when we achieved the knowledge of good and evil. And that's sometimes called the law of the heart. In other words, you're born with this knowledge. Nobody has to teach it to you. You know certain things. And so, if you violate that law, then we have the written law to tell you what to do. Well, as it turned out, there were a lot of people, apparently, who ignored the law of the heart. And so, at some point in time, out came this thing called the Ten Commandments. And we told people what to do. You can't do this, you can't do that. Well, that law was not for the lawful person. That law, the Ten Commandments, was for the person who ignored his deal. And this reflects in our system of jurisprudence, because for example, to pick a very obvious example, you know that one of the Ten Commandments is thou shalt not kill. Now you're driving down the street, you're doing 25 miles an hour in a 35 mile an hour zone, and a little kid runs out from between some parked cars and you can't stop and you kill him. Did you violate the commandment that says thou shalt not kill? No, in our system of thought, our philosophy, you are not held responsible. Why? Because you did not have the intent. Okay? If you have not the intent, then there is no conviction. You are not persecuted for accidents. Now that's different from what goes on in Islam. And I read about a case where this guy, an American, that might have had something to do with it, I don't know, but he parked in a parking lot, okay? And his car was the only car there. And he went into the building. While he was in the building, a hot rodder came around, happened to be a native, okay? And he went too fast to get around that curve. And instead of navigating the curve, he went off into the parking lot, hit the American's car, and I don't know if it killed him or not, but certainly it created major damage, okay? So it got into court, Islamic court. And the American was held responsible, and the judge explained it to him, that what had happened was that the American had made a choice. He could have parked somewhere else. But because he made the choice that he did, he was being held responsible for his choice. That's a little different way of looking at things.